Welcome to the North Carolina Court of Appeals. We're fortunate today to have much better weather than when we were first scheduled to be here. I'm Judge Valerie Zachary. To my right is Judge John Airwood. To my left is Judge April Wood. To your right is Senior Deputy Clerk Eddie Sanders and our officer Tom Salou. This afternoon, we're hearing oral argument in the case of Stein v. Hall. Let's go ahead and begin. Have you divided your argument time?
Yes, ma'am. We are reserving 5 minutes, and while I do not plan to take the full 25, I will be sharing that time with Mr. Dale, who is representing the auditor.
Okay, thank you.
May it please the Court, Matthew Tilley with Womble Bond Dickinson for the legislative defendants. I'm joined by Martin Worf, Nelson Mullins, who is also representing legislative defendants, and Mr. Alex Dale, who is representing the auditor. The General Assembly's decision in Senate Bill 382 to transfer the Board of Elections to the auditor, to give to the auditor the power to appoint the Board of Elections members, and to make corresponding changes to the county boards of commission, is a natural outgrowth of a decision that the founders and drafters of our Constitution made at the very beginning. And in the current Constitution, it's reflected in Article 3, Section 7.1, which makes the members of the Council of State part of the executive branch, and in Article 3, Section 7.2, which says the General Assembly shall prescribe their duties by law. This is that case. This fits in directly into that text.
So does the legislative reallocation of duties render all the members of the Council of State fungible?
It renders them fungible insofar as the General Assembly is reallocating duties that are prescribed by law. We're in a unique position here. The Supreme Court has weighed in to some degree on the writ of supersedious, and that has now been reflected in 2 decisions. Judge Zachary, one in which I believe you were involved just a month ago, Stein versus Utilities Commission, and Stein Commission's case. All of those cases say basically the duties, powers, and functions under the Constitution fall into 3 flavors. One, those that are prescribed expressly by the Constitution to a certain officer. Think the governor's powers, commander-in-chief of the National Guard or the militia. Those that are inherent in an office, and those that are prescribed by law. The Supreme Court in Stein, in the ruling above on which we will call Stein 1, made the point that those that are assigned by law can be assigned, if they're not prescribed specifically by the Constitution to one Council of State member or another, to any of the 10. And this is that case. The General Assembly has made the decision that it makes sense to have the auditor, whose office involves accountability, involves ensuring compliance with law, to appoint the members of the Board of Elections. Now, the governor will take the position and sometimes describe that as having the auditor oversee elections. It's a step removed from that, and our case law and the other decisions that I just mentioned all reflect the notion that appointment is not the exercise of the individual's power. As I said, we start this case in a unique position. The Supreme Court has said that the original theory on which the governor's complaint traveled doesn't hold, and that the summary judgment decision below, which adopted that theory, was in error, unambiguously misapplied this in the Supreme Court's case law.
Well, going back to what you just said a little earlier, is it your contention that the work of the Board of Elections is related to the auditor's constitutional role?
It doesn't have. We don't argue that it has to be. That's one of the governor's theories. Is the governor essentially at this point now needs to show that the Constitution somehow gives him the exclusive power to appoint members to the Board of Elections. Absent that, this is a set of statutory officers that are set by law. The power to appoint them is set by law and can be reassigned by law. One of the governor's theories is he cites, and he really seizes on, a concurrence from Judge Dietz in that Supreme Court order from May, and where Judge Dietz said that, well, every Council of State member has a core function. It can also, the General Assembly can also assign duties that, by law that are related to that core function. He drew that from Article 3, Section 11, which I respectfully submit, one, doesn't say, it doesn't deal with who appoints whom. Instead, that clause very specifically said that there shall be no more than 25 principal departments by July 1, 1975. All the agencies must be consolidated into those, and that they shall be grouped by major purpose to the extent practicable. I believe that the actual clause that we're traveling under here for authority, although the General Assembly has plenary power here, but if it needs to cite express power, it's got it under Article 3, Section 7.2, where it says the duties of the Council of State members shall be prescribed by law. So to answer your question, Judge Zachary, no, we don't believe that it has to be related. We believe there's certainly a rational reason why that it's been assigned to the auditor, and there have been incidents involving elections and election integrity that might have motivated the General Assembly to make this policy decision. But at bottom, it's a policy decision that belongs to the General Assembly to determine which Council of State member gets which statutory duty when you're not dealing with one that's specifically assigned to a specific constitutional officer. As I said, the governor essentially, to win this case, can no longer travel on his original theory, which is that the take care clause and the vesting clause require that the governor and the governor alone has the power to execute all laws and therefore must have a sufficient control every board and commission through appointment power to ensure it reflects his views and priorities, and that is required by McCrory, Cooper, and Cooper confirmation. The Supreme Court made clear the take care clause does not vest exclusive power in the governor. Instead, take care duties are shared by all Council of State members, and as I just said, can be reallocated among them. And that for that reason, McCrory, Cooper 1, and Cooper confirmation were inopposite and did not apply to this case, just as they said in explicit disclaimers in the footnotes to each one of those decisions. That leaves the governor now trying to find a new theory. It leaves the governor trying to show somehow that the Constitution requires that he have exclusive appointment power over the Board of Elections. He comes up with a number of theories for those, but I would argue that none hold. The standard of review here is pretty clear. He needs to find an express provision of the Constitution that explicitly prohibits the General Assembly's decision in this case. He can't do it. He argues that, well, maybe it's inherent in the governor that the governor must appoint all elections officials. But there's nothing in our history that would suggest that. Indeed, in the 1890s, when the Board of Election was first started, the legislature appointed all of its members. The governor took it over for a time, had that appointment power and took it over for a period of time. But just because a statutory duty was assigned one place doesn't mean it can't be reassigned.
How long was it with the legislature?
It was with the legislature at least a decade or more.
Okay.
And how long was it with the governor?
It probably was with the governor, served 80 to 100 years. But that doesn't mean that that was an understanding that that was constitutionally required. There's nothing that the governor can point to in constitutional history that would suggest that chief executives are responsible or understood by the people to be the only officer in the plural executive branch that can be the one to appoint elections officials.
So if the elections officials were appointed by the General Assembly, it would then seem as though that perhaps was not necessarily considered part of the executive branch, but you can see that now the Board of Elections is actually an executive agency.
For this point, we'll concede that the Board of Elections is an executive agency. I mean, Cooper 1 held that the Board of Elections performs executive functions. We're not going to argue or dispute that. I think you could say that there is something unique about elections and their role that they play within our democratic process, that they're not the typical executive function, and there's reasons for independence. But we're not going to argue, at least before you, that that's not executive. It doesn't really matter. The appointment of statutory officers is something, and who appoints a statutory officer is something the General Assembly gets to decide. In Stein Commission's and Stein, the Utilities Commission's case, pulling off the Supreme Court's opinion, the court made clear that the relevant question is not whether the governor gets the number of appointments when you're talking about an allocation between or within the executive branch, but whether the executive branch as a whole has enough appointments to execute the laws. To a certain extent, they are interchangeable when you're talking about duties that don't exclusively belong to any one of them. And that's what's at issue here. It's an intra-branch transfer that keeps all of the relevant power in the executive branch. And there's really and can be no charge that there's been an interference with the core function of the executive. The governor tries another argument, which we just talked about, the major purposes doctrine. He points to Article 3, Section 11, which talks about, as I said, the collection of agencies and their grouping and where they're housed. But again, that doesn't talk about who appoints. And the major purpose test that he proposes comes from the concurrence of a single justice that has never been applied in any case. In Stein commissions and Stein's utilities commissions, this court's cases, but did not go down that road. They recognized Judge Dietz's concurrence, but did not use it as the operative test. And if you were to try to impose that as an operative test, you'd have a lot of questions really fast. How do you determine what the constitutional core role of Council of State members who have not historically existed really are? Tell me what the core understanding is at common law of a commissioner of insurance. Figure that part out, and then you have to say, well, even Judge Dietz would say it's not just the core functions that they can be assigned, but those related. What level of relatedness? Is it rational? Is it just those duties that are substantially related to a core function, however defined? Or is it something that is only rationally related? And where does the level of deference come in for the policy-making decisions of the General Assembly in that level of analysis? Is it the General Assembly's decision to determine what is and is not rationally related to the view of the role of an auditor? Again, that test, I would submit, to put it colloquially, is just not ready for prime time. There's not enough around it to make it a judicially manageable standard, but it hasn't been applied by any case law. And at this point, Your Honors, I would submit that you're bound by Stein commissions and Stein's utilities commissions, which says we look at the branches vis-a-vis each other and do not worry about that intra-branch transfer. The governor also puts forward a theory called the real-time legislature. He suggests that the legislature can pick and choose between its preferred office, Council of State officers, and in doing that, it can effectively control the execution of the laws. With due respect, that's not how it can work. The legislature has bicameralism requirements, presentment requirements, multiple days of reading, so it's not like the legislature could ever actually rule in real time. Even if it could set the rules and policies, that doesn't mean that it's directing the execution of the laws. Really behind that, what I call that real-time legislature argument and theory, is the governor's suggestion that somehow at some point the electorate's understanding of who's going to fulfill what role constitutionalizes. It fossilizes and becomes ossified and sticks. But you have to square that with the text of the Constitution, which in Article 3, Section 7.2 says that the General Assembly shall assign the duties and powers of the Council of State members, and in Article 3, Section 5.10, where it says it can reassign and reorganize them.
So, doesn't our Constitution provide that the legislature, by giving the legislature all this, plenary power, they can manipulate things if they want to, and the public's remedy is to not reelect those legislators.
Correct. There's an electoral remedy there, and the real problem that I see with that kind of cycle argument that they have, the real-time legislature argument, is one, a misunderstanding. The legislature, yes, could set policy in real time, I guess, but there'd still be a separation of powers between that and execution. Choosing who executes is even still not going so far as to control execution. And there's an electoral remedy, but the last step there is, how do you define that free salt cycle? How do you decide when it would be constitutional to reassign, which it obviously must be because the text of the Constitution says that that's possible, says the General Assembly has that power. And when would it not? When would the free cycle be? When would the governor's theory that it would be unconstitutional to move for instance, the Board of Elections to the Department of the Auditor and the appointments of the Board of Elections to the Auditor be unconstitutional. The governor doesn't give you any objective standard by when that freeze-thaw cycle, I created my own tongue twister, would occur and when you could judge it. And so he really gives you an unworkable standard. And that goes to the very end. The Supreme Court, in what we call Stein 1, suggested that not only did the panel below err because it found McCory and Cooper were controlling when those cases clearly said they weren't, that it found that the take care clause was exclusive when it clearly is not in a plural executive model, or that the court found the underlying legislation unconstitutional without being able to point to an express prohibition in the Constitution per McKinney v. Goins and long line of history from our Supreme Court. And one of the last reasons, and the court cited Hart v. State on this, cited its political question cases on this one, said this is at the end a political question. The Constitution textually commits the decision to decide these legislative or statutory duties, which council of state member will get them. It expressly gives the legislature the power to reassign them. And in doing so, charges them with a policy decision that is meant for the political branches. It has a political remedy, to your point, Judge Zachary. And then finally, would lead itself to no judicially manageable standard to second guess that policy decision. That's where we stand. And so we would submit that the court has signaled that this is a political question. You don't have to go that far. You can certainly just simply say that it's a decision that is authorized by the Constitution itself, and it is one that the Constitution anticipates the General Assembly will make in line with Stein Commission, Stein's Utilities Commission, and the Supreme Court's decision on the writ of supersedious above. With that, I would...
Well, you would contend, based upon your brief, that the General Assembly has the power to move any and all the functions that the governor now does to someone else in the Council of State without any judicial oversight, because those would be political questions and therefore not justiciable. Isn't that the base of your argument if we get cut all the way to the bottom of it?
Yes, sir, except save those duties that are expressly given to the governor in the Constitution. And that's where the governor does have some set of powers. And if you look at Article 3, Section 5, there are things like the commander-in-chief power, the information power, the clemency power that are expressly given to the governor.
Well, and Section 1 says that the executive power of the state shall be vested in the governor too, doesn't it not?
But the Supreme Court has said that if you look at that structurally, you have to understand that within a plural structure. Article 3, Section 7 says there are now 10 other members of the Council of State, and that they shall have those duties prescribed by law. If all executive functions, executing every law, had to be done by the governor, it would be nonsensical to say that other powers could be assigned to the Council of State members, because assigning any power to them would infringe the concept that we have a unitary executive, or that the governor has to exclusively execute every law. So again, structurally, you have to, looking at our Constitution, reading all of the clauses in peri materia, as you must do, you have to come to the conclusion that we have a plural executive, which is what our founders meant to do. They meant to disperse executive power as a check against government. And in doing that, there has to be a mechanism for allocating duties among them.
So our Supreme Court has said Cooper 1 is an opposite, because in that opinion, there was a different setup where the General Assembly was trying to create a new bipartisan board and was giving the governor directions on who exactly the governor was allowed to appoint, because it had to come from a certain list. And
right.
So that's clearly different than this, where the entire appointment has been removed from the governor to the other. But within that opinion, though, there's numerous paragraphs of discussions about how the governor is the leader of the executive branch and how the governor shall have the ability to implement his or her policy preferences. And it's throughout the entire opinion that the governor is the leader of the executive branch, is able to implement his or her policy preferences. So how is that inapplicable here when, in this particular instance, the state auditor is of a different political party than the governor, so theoretically is, or realistically, is going to be making appointments that are in opposite to the governor's preferred policy preferences?
2 points. One is that as far as the point about the governor alone, you're right. Cooper 1, McCrory all dealt with intra-branch, governor versus the legislature, not intra-branch. And so for all that reason, all of those decisions said we're not expressing no opinion on intra-branch issues. But as to the views and priorities, that's the governor's theory that the Take Care Clause gives him the power to make policy. Cooper confirmation clarifies what that power really is. It's the power to make those decisions delegated by the General Assembly to the governor. And they said that the clause contemplates, words Justice, we will have the, Martin, he will have the ability to affirmatively implement policy decisions that the executive branch agencies subject to his control are allowed through delegation by the General Assembly. So it's not the concept that the governor has a freestanding policymaking authority. He doesn't. Take Care Clause, charging him explicitly to follow the law, doesn't give him a policymaking power. But if he is charged with a discretionary decision, he has the power to make that discretionary decision. Somebody else can't make it for him. In this case, he's not been charged with a discretionary decision. That's been allocated to the auditor. This is the intra-branch case that all McCrory, Cooper 1, and Cooper confirmation all said they weren't touching. And so the only case law you have before you is the Supreme Court's order in Stein 1, what we call Stein 1, and other panels of this court that have ruled on similar intra-branch allocations and said that they're constitutional. With that, I do want to leave some time for my colleague, Mr. Dale, to speak on behalf of the auditor. Thank you.
Thank you.
May it please the court. My name is Alex Dale. I'm here on behalf of the North Carolina State Auditor, Dave Bullock. I want to dive right into it because my time is short. The arguments and the issues that the governor is going to present to you and has presented to you in the briefs have already been decided by our Supreme Court and by this court. We submit to you that the opinion of the Supreme Court in this case, the case we call Stein Commissions in the briefing, and the case Stein versus Hall or Stein versus Utility Commission, which was just issued in January, foreclose every argument the governor has made. Now, I'm sure the governor is going to get up here and argue there's daylight between those opinions and the governor's position. We submit to you there's not, because even though the parties may be different, the facts may be different, the case of in re civil penalty is clear that it's talking about the legal issue. And the legal issues here are the same as those other opinions. So we submit that those opinions bind this court. I want to dive right into the governor's arguments, specifically in my limited time. First of all, I want to hit the core duties argument that my colleague has hit a little bit too. First of all, that argument I submit to you is atextual. It's outside of the Constitution. It also has already been rejected in the Stein v. Hall or Stein v. Utilities Commission case that came out in January. I'd also add that in the Supreme Court's opinion of Harper versus Hall, Supreme Court said there's no hidden meanings in the Constitution. There's no secret sauce out there that we have to figure out. It's plain text. And so this idea that there's some hidden core purpose does not fit Harper versus Hall's clear explanation of how our Constitution should be read. Additionally, if we even were under that core duties test, we submit to you that the auditor would fit that role. The auditor's role has expanded vastly and quickly over the years. It's much more of a transparency role, a government accountability role, and that is precisely what an independent board, like the State Board of Elections, needs in terms of who handles the appointments there. And then lastly, my colleague, this test of core duties is completely unmanageable. Are we going to litigate every duty assigned to a member of the Council of State? Of course not. And what this really shows is this is a non-justiciable political question. It's a policy decision, and under Harper v. Hall, policy decisions remain with the General Assembly. And that's exactly what happened here when they exercised their express authority under Article 3, Section 7, Clause 2, and under Article 3, Section 5, Clause 10, when they reorganized and assigned new duties to the auditor. The governor is also likely to argue to you my colleague called it a real-time test of some kind dealing with the separation of powers issue. This is not a separation of powers issue at all. It's all interbranch. But more importantly, I think we need to look at Harper versus Hall on this issue. Harper versus Hall says two things that are very important. First, it says separation of powers is a binary issue. It's not one of degree. So if it's binary, it has to be clearly a separation of powers issue. It can't be something where there might be a potential encroachment if there's this frequent transfer. It's a binary question. Is it between two branches or is it not? This is all interbranch. But secondly, in Harper versus Hall, the Supreme Court said, a branch's exercise of its expressed authority by definition comports with the separation of powers. And that is exactly what's occurring here. So for these reasons, we'd ask this court to reverse the trial court's order and to uphold the constitutionality of the session law.
Thank you.
Good afternoon. May it please the court. I'm Eric Fletcher from Brooks Pierce, joined by my colleague Dan Smith on behalf of Governor Joshua Stein. I want to start with the Supreme Court's order in this case that denied supersedious and what it does and doesn't tell us about how this appeal should be resolved. To hear the appellants tell it, the Supreme Court effectively resolved this case, but that's not true. First, the majority opinion repeatedly said that this case raises issues of first impression and that the court was not deciding them. Instead, the Supreme Court emphasized that the defendants had already noticed their appeal and that this court would decide the issues which it described as vigorously contested in the first instance. Second, it's also noteworthy that the Supreme Court had the governor's petition for just 3 weeks, and their order resulted in 5 separate opinions. The court majority was clear that the Take Care Clause imposes a non-exclusive duty that extends to the Council of State, and we don't contest that. But 4 justices wrote individually, each expressing very different views on the vigorously contested constitutional issues presented by this case. So, to summarize, the Supreme Court issued a non-precedential order in which they told us that they view this case as presenting important questions of first impression, that they were not answering those questions, and that there were many different ways to resolve them. The Supreme Court was clear that it's up to this court to decide the important constitutional questions in the first instance. With respect to this court's decisions, and in particular the recent Stein versus Hall decision, there are a few reasons why that's not dispositive here. First, the court there addressed a narrow, specific question. Could the legislature assign to the treasurer a single appointment to the State Utilities Commission? Well, it's true that the governor raised some arguments in that case similar to the arguments the governor raises here. The court's decision did not resolve them. For example, the court did not hold that the General Assembly has the authority to assign any duty to any executive official at any time. As I read the court's decision, I don't see a place where the court definitively held that the legislature's power to assign duties to the Council of State is not constrained by the separation of powers, Article 3, Section 7, subsection 1.
Do you contend this is a separation of powers case?
We do, Your Honor, yes. I think the separation of powers in particular, going back to your very first question, Judge Zachary, on whether or not the legislature views the Council of State members as fungible, I think that they clearly do. They say so in their briefs. And if that is the case, if the members of the Council of State are actually fungible and can be assigned any duty, then there is no separation of powers. The legislature can assign to the members of the Council of State any duty that it wants until it achieves the outcome that it wants, and the law is executed in the way that the legislature wants. And so I think that very clearly implicates the separation of powers. So this case at first glance may seem to turn on partisan politics. The state board and county boards have important roles to play in managing our partisan elections, but I want to be very clear that politics aside, this case raises core fundamental questions about the structure of our state government. As we were just discussing, the constitutional issue of first impression that this court is asked to resolve is simple. Does our Constitution permit the General Assembly to assign any executive duty to any member of the Council of State at any time for any reason, or no reason at all? Or does our Constitution impose limits on this legislative power? On the merits, the legislature's position is that there are no limits on their power to assign executive duties on the Council of State. They say that they can assign tomorrow election administration to the Commissioner of Agriculture, that they could send agricultural policy to the Commissioner of Insurance, and they could assign road building to the Superintendent of Public Instruction. They even argue, as you just heard, that these arguments should not be, or these assignments should not be reviewable in court. Our view is different. We think the Constitution imposes limits, and there are three specific limits. First, the separation of powers imposes a limit. If the General Assembly has the unfettered power of reassignment that it claims here, then the separation of powers is meaningless. The General Assembly can control execution of the law if it can constantly reassign the duty of execution until it achieves its desired outcome. Second, Article 3, Section 11 imposes a limit by requiring that duties, powers, and functions be assigned to offices according to their major purposes. The assignment of duties to the auditor must be consistent with the major purpose of the auditor's office. Finally, the executive offices that make up the Council of State are created in Section 7 of Article 3, which also imposes a limit. Subsection 1 of Section 7 says, for example, that, quote, an auditor shall be elected by the qualified voters of the state, end quote, every 4 years. This constitutional language creating the various offices of the Council of State and calling for their direct election by the people imposes a limit on the legislature's power to assign duties to those executive officers. The people are not electing a series of executives who are interchangeable with one another. They are electing individuals to fulfill specific positions created in our Constitution. In combination, these provisions require that any duty assigned to a member of the Council of State be sufficiently related to the major purposes of their office, or the major purpose, of their office. Now, the facts that gave rise to this case, I think, are very important, and they address and are responsive, I think, to Mr. Tilley's argument about the real-time General Assembly and this idea that there's an electoral remedy for assignments of power that the people don't approve of. Senate Bill 382 was enacted in December 2024, shortly after Josh Stein was elected governor. At the time of the 2024 general election, the governor had been appointing all members of the State Board of Elections for more than a century. The auditor had never had any role in elections. No voter in the 2024 elections could have reasonably expected that the auditor they elected would become responsible for appointing and supervising our state's election officials. It's never been part of the auditor's role in our state, or any other state for that matter, and it's inconsistent with the meaning and duties of the office. But in Senate Bill 382, which was introduced just days after the election, dispensing of any electoral remedy for what was happening because the bill was enacted by a legislature after Election Day, it was enacted over the governor's veto on straight party lines, and in that bill, of course, legislative defendants completely restructured the power to supervise the administration of election law in our state. Think about the implications for future elections. Imagine that a majority of North Carolinians are dissatisfied with the administration of elections, so they elect a new auditor. With the power they claim here, and following the facts that led to this case, the General Assembly would be free to effectively ignore the election results and just reassign the authority to appoint the Board of Elections to any other Council of State member of their choosing. This is inconsistent with the separation of powers, and it's inconsistent with the popular sovereignty that is the source of all political power in our state. To be sure and clear, we have a plural executive in our state, and the General Assembly has a central role to play in assigning powers and duties to executive officials. But we also have an express separation of powers clause that clearly distinguishes between the legislative power and the executive power. And our plural executive consists of 10 specific executive offices that are each created in our state constitution. The best way to harmonize the separation of powers with our plural executive is to recognize that our Constitution empowers each Council of State member to have duties that are consistent with the major purpose of their office. Our Commissioner of Agriculture can implement agricultural policy, but cannot manage our pension fund or implement our election laws. Our Superintendent of Public Instruction can implement education policy, but cannot execute agricultural policy or be responsible for road building. The implication for this case is simple. The auditor's major purpose is to perform independent reviews of state agencies. This understanding comes from the text of the Constitution and the meaning of the word auditor. It's consistent with and reflected in the history of the auditor's office from its inception in 1868 to the present. The auditor's major purpose is not related to the supervision, administration, or implementation of our state's election laws. In fact, giving the auditor control over an executive agency is inconsistent with the independence that is a hallmark of the auditor's role within our system.
I have a question for you. Because it appears as though the governor is not contesting the fact that the legislature moved the administrative functions of the Office of the State Board of Elections to be under the umbrella of the Office of the Auditor. The contest is about the actual appointment of the board members. Is that correct?
That's correct, Your Honor.
And explain for me what you deem is the difference there.
Sure, it's a good and important question. So Senate Bill 382 at the outset in the first couple of sections is clear that, with one limited exception where the auditor has some role to play in budget functioning, that the members of the state board will operate independently once they are on the state board. And so the key issue, and this gets to some of the discussion from counsel for the legislature and the auditor about the power of appointment. If you look at McCrory v. Berger, Cooper v. Berger, the Cooper 1 or Cooper Board of Elections case, it's hard to keep them all straight, and we have different names for them, but what the court talks about, the Supreme Court talks about in those cases is control over executive agencies. So there's no, to your earlier line of questions, there's no question that the State Board of Elections itself is an executive agency. And so then the question is, who has control over that agency? And here it's unambiguously the auditor. He is the only executive official with the power to appoint the members of the State Board of Elections and the chair of the County Board of Elections. He has the only power of removal that was switched over to him in Senate Bill 382, and he has the power to fill vacancies. And so the constitutional issue is that the auditor now has the control over the State Board of Elections and the County Boards of Election, both directly through his appointment of the chairs and through the State Board's appointment of the rest of the members of the County Boards of Election. So I think that issue of executive control, it is that control, the assignment of control to the auditor that raises the constitutional question here. Fundamentally, the General Assembly would turn the elected members of the Council of State into interchangeable executive officials that can be assigned any executive responsibility that the legislature chooses. That's not the structure of government that the people adopted in our Constitution. They chose a system in which the Council of State members are directly accountable to the public. They have defined roles. If the people are dissatisfied with the way that they are effectuating those roles, the people can elect new people into the positions. The people chose a system in which the legislative branch makes the laws, but the executive branch and the executive officials directly accountable to the people are responsible for implementing those laws. Well, the General Assembly has broad power to assign duties to the Council of State. Those assignments must be consistent with the major purpose of the Council of State office to which they are assigned. Again, here, the assignment in question is unequivocally outside the scope of the auditor's major purpose, which is to conduct independent reviews of state agencies. It violates the separation of powers.
Now, what is your rationale, or where do you point to that they've got to be consistent with with the roles? In the Constitution itself, where do you?
In the Constitution itself, yes, a good and important question, Judge Arrowwood. So I think first, Article 7, Section 1, which actually creates the offices. It says the people shall elect a commissioner of agriculture, the people shall elect an auditor, the people shall elect a treasurer. I guess technically it creates 8 of the offices. The governor and lieutenant governor are created a little bit earlier. But in creating that position, an auditor, the people were creating a position that would have the responsibility to conduct independent reviews of state agencies, to ensure that the public purse was protected, to ensure that state agencies were following the law and doing what they were supposed to do, being good stewards of the public purse in particular. And so that is a source of limit itself, just the actual position. When the people create a commissioner of agriculture, they are creating a position that will be responsible for the implementation of agricultural policy in our state. I think also in Section 3, or Article 3, Section 11, where you have the requirement that duties, functions, and powers be assigned to departments and offices according to their major purposes, that is another source of the limits. So you've got the major purpose of the auditor, which just comes from the text, the meaning of the word auditor. And then you have a separate command to ensure that duties are assigned consistent with that role.
So how do you explain something like amusement parks? You know, the Commissioner of Labor is in charge of Carowinds, right? How does that fit into the core duties of the Commissioner of Labor?
Sure. I mean, I think that with respect to the Commissioner of Labor, I can't say that I've undertaken in preparation for this argument a historical analysis of the role of the Commissioner of Labor and why,
Nor have I.
why it was created. But I think that there will be, so first you would want to look to the Commissioner of Labor. What does Commissioner of Labor mean in terms of plain text? What are the dictionary definitions there? You would then want to look at the kind of contemporaneous documents when the position was created. One thing we cited in our brief, for example, with respect to the auditor, is the initial statute in 1869 that set out the initial duties for the auditor after the position was created in the 1868 Constitution. So what, if anything, was said in the debates when the people were creating that position? So you determine what is the major purpose of the Commissioner of Labor. Regulating labor generally and ensuring safe labor conditions, I think, is likely to be a key portion of that, or a key part of the Labor Commissioner's duties. And so then the assignment, I mean, I think, again, I'm speculating, so we're getting into dangerous territory about what the Labor Commissioner's role would be, but as I understand it, they conduct inspections of certain facilities to ensure their safety. And so I think that would be potentially where that consistency arises, assuming it does. And my colleague, Mr. Smith, has pointed out, I think consistent with what I was just saying, that a big portion of this was protecting workers from dangerous machinery. The Labor Commissioner arose during industrialization and as factories and other, as factories were spreading throughout the land. And so I think that would, again, be part of the inspection role that the Commissioner of Labor has.
What precedent would you rely on to support your position that the General Assembly's legislation is unconstitutional?
Another good and important question. So I think a few different lines of precedent. I think there are a number of cases from the Supreme Court that recognize specific or inherent roles for the members of the Council of State. So Martin v. Thornburg, for example, recognizes that the Attorney General has the obligation and the duty to represent the state in court, and that carried over from the common law understanding of what the Attorney General's role is and was, and regardless of whether that specific duty is spelled out in the Constitution or in statute, that it exists, that that's part of the Attorney General's role in our state. Justice Dietz, in his concurrence in the order in this case, talks about the role of the state superintendent of public instruction. And the state superintendent is specifically mentioned in Article 10, Section 4 of our Constitution, which says that the state superintendent is responsible to be, or is the chief administrator and secretary of the State Board of Education. And the legislature passed legislation, I think in 2014 or 2015, creating a position of a CEO of public instruction that was to report to the state board, but not report to the Department of Public Instruction. And a lower court held that that was unconstitutional and inconsistent with the state superintendent's role. So I think case law like that is clear that each member of the Council of State may have either specific duties set out in the Constitution, as in the case of the state superintendent, or inherent and well understood duties, as is the case with Martin v. Thornburg. I also think, to your earlier line of questions, that certainly the separation of powers cases, Cooper v. Berger, McCrory v. Berger in particular, give rise to many of our arguments here, that control over executive branch agencies, who has the power to appoint, who has the power to remove, what other mechanisms of control exist, is very important. Limits on the legislature's ability to interfere with the executive, which the constant reassignment of duties would interfere with the executive's ability to implement the law. So I think those are the cases that we really point to in our briefs and that I would point the court to in resolving this case.
Could you address Mr. Dale's arguments about in re civil penalties and why the cases that he cites as constraining this panel do not?
Sure. I think that in particular, I guess we'll call it the first one, Stein commissions, the arguments that we raise here just weren't raised in Stein commissions. So that's the case that involves the Board of Transportation, the Environmental Management Commission, Commission for Public Health, many others. The court just had no occasion there to address the issues that are raised here, which are whether the General Assembly has an unfettered right or ability to assign duties to any Council of State member. The core issues there really revolved around the take care clause in particular and the vesting clause to some extent, but didn't deal with what Mr. Tilley calls the intra-branch transfers and what limits exist on intra-branch transfers. And I think the same is largely true of the more recent case that dealt with the Utilities Commission. Some of those arguments were raised there, but I don't think that the court's opinion, as I read it, squarely addressed or decided those questions. There was a single appointment to the state treasurer, assigned to the state treasurer, that went to the Utilities Commission. The court held that that was constitutional, but in so doing, it didn't address what is the constitutional role for the state treasurer, what is the constitutional role for the state auditor. It certainly did not hold that the General Assembly has an unfettered right to assign any executive duty to any executive official at any time.
But in that particular case, didn't the governor still retain appointment powers to some of them?
You're right, Judge Wood, that with respect to the Utilities Commission as a 5-member commission, so the legislature has 2 appointments. The statute that was at issue there, the legislature has 2 appointments. The governor has 2 appointments, and the state treasurer got 1 appointment. And that was the issue there. So it's not the assignment of all 5 appointments to a Council of State member. So For the reasons that we have outlined here and outlined in our brief, we urge the court to affirm the trial court's judgment, and unless the panel has any further questions.
We do. Thank you.
Thank you.
To respond quickly to the governor's arguments, he started with the argument that Stein won, and then this court's decisions and Stein commissions, and what we'll call Stein Utilities Commissions from January, did not address the issue at hand. To be very clear, Stein commissions and Stein utility commissions adopted the Supreme Court's reasoning in Stein 1. Reading directly from Stein Utilities Commission, directly as Judge Murray found in his concurrence in Stein commissions, was not whether the governor alone appoints a majority, but whether the executive branch holds a majority of appointments. The governor's duty to take care that the laws be faithfully executed is a non-exclusive duty conferred upon all 10 council of state members. Here, the governor and the state treasurer, this is talking about the Utilities Commission at the time, hold the majority of appointment power and finds it constitutional.
So the governor still retained the power of appointment, right?
And interestingly, the governor argued that because the Utilities Commission was not transferred in full to the treasurer, that split between the governor and the treasurer was somehow unconstitutional. The court said no, we're looking for the purposes of a separation of powers analysis between the branches and the allocation of powers of the branches. There's no allegation in that case that the Constitution specifically assigns the regulation of utilities or the power to appoint utilities regulators to the governor. Here, there can be, because the governor can't point to any, there is no constitutional provision that says the governor shall appoint every elections official or every member of the Board of Elections. It's just not in the Constitution. The court also in Stein's Utilities Commission addressed the Article 3, Section 11 argument, which again, with the understanding that the standard review requires an explicit limitation from the express text, that clause says not later than July 1, 1975, all administrative departments and agencies and offices of the state shall, and their duties, powers, and functions shall be allocated by law among not more than 25 principal agencies. It goes to where they're housed, not who appoints them. The court then said this section does not address the allocation of duties between council and state members. So if we're talking about an in-re civil penalty issue, Stein Utilities Commission, as we call it, the January decision, addressed their argument that Article 3, Section 11 somehow gives rise to the major purposes test. But I would highlight on that point, on the major purposes test, two things. One was the argument that Martin v. Thornburg and State Superintendent versus Board of Education somehow suggested their inherent powers. Martin v. Thornburg observes that the Constitution gives no express powers to the Attorney General, but instead gives him common law, he's given common law powers by statute because the Constitution says his duty shall be prescribed by law, the same language at issue here in Article 3, Section 7.2. In the State Superintendent versus Board of Education case, there's an express provision on point that says the State Superintendent shall be the Chief Administrative Officer and Secretary of the Board of Education. There is no such clause here. Judge Zachary, you brought up why does the Labor Commissioner regulate Carowinds, why does the Labor Commissioner regulate elevators? And notice the amount of struggle that it took to come to a definition that would allow that, because it's related, but somehow explain why an auditor who is responsible for not only, by all descriptions, not only financial audits, but operational audits, and in the words of the Governor's Council, ensuring compliance with the law, would not be an official who would be charged with determining who should be appointed to the Board of Elections. Again, there's nothing inherent in the word auditor that would give us such a consistent definition that it would give you a judicially manageable standard. But at the end of the day, the question is, and the last argument that the governor makes is that there's an expectation on the part of the electorate. And I would say that the best note that the auditor would not be in charge of the Board of Elections, because that's not how it was when they went to the polls. I would say that the best statement of their expectations, though, would be in Article 3, Section 7.2, when it explicitly says that the members of the Council of State's duties shall be prescribed by the General Assembly. The electorate expected that the General Assembly would make that decision, that it could change that decision, and it could reassign those duties. If there are no further questions from the panel, I thank you for your time, and we ask that you overturn the decision below.
Thank you. That concludes oral argument in this matter. I want to thank you, counsel, for your excellent arguments this afternoon. We'll take this under advisement.